Hello guys, welcome to 6-7, your daily political update. This is me Sanjay Bhargav. Let's get started. In India, every voter is not automatically a candidate, but every candidate must first be a voter. Today we explore how the Supreme Court has drawn the line between the right to vote and the right to contest, and why laws like the Anti-Defection Law and the criminal disqualification rules remain controversial. Let's understand the difference between right to vote and right to contest. Now let's discuss the right to vote. It is a statutory right under the Representation of People Act 1950. In Jyoti Basu vs. Devi Ghoshal 1982, the court ruled that a right to elect, fundamental though it is to democracy, is anomalously enough neither a fundamental right nor a common law right. It is a pure, simple, a statutory right. Let's discuss about the right to contest. It was a statutory right under the Representation of People's Act 1951. In the case of Ram Chandra Chaudhary versus Roop Nagar Dudh Utpadak Sahkari Samiti Limited 2026, the court ruled that the right to contest an election is not a fundamental right, but a statutory right, subject to the conditions prescribed by the statute or bylaws. Now let's discuss the how 10th schedule anti-defection law affects the right to vote and right to contest. In Kuhato Hollahan vs. Jatillu 1992, Supreme Court upheld the 10th schedule but noted freedom of speech of members is not absolute, it is subject to the provisions of the Constitution including the 10th schedule. Its impact on the right to vote inside the legislature is legislators cannot vote against the party whip, their voting freedom is curtailed. Its impact on right to contest is disqualification under the 10th schedule can remove the legislator from office, indirectly affecting future contesting. Let's understand the criticism of the anti-defection law with regard to right to vote and right to contest. It weakens the independence, legislators become bound to party leadership, reducing the free will. Democratic paradox. Voters elect representatives, but those representatives cannot freely vote in the House. Judicial concern. Critics argue it undermines the deliberative democracy by silencing the dissent. Let's understand how the criminal charges and disqualification affects the right to vote and right to contest. The law states that conviction for certain offences disqualifies candidates for 6 years after release. The court ruled in Lily Thomas 2013 judgment, once a person is convicted for an offence under the Section 8, he or she cannot continue as a member of parliament or legislature. Let's understand how criminal charges affect right to vote and right to contest and its impact on right to vote. Convicted persons can still vote unless in prison. Impact on right to contest. Conviction bars contesting. Charges alone do not bar contesting. Example. Congress leader, current Chief Minister of Telangana, Revanth Reddy has faced multiple criminal cases but contested and won since charges is not equal to conviction. Let's understand the criticism of the criminal charges and the disqualification rules with regard to right to vote and right to contest. Delay in trials. Politicians exploit slow judicial process to contest despite serious charges. It undermines the democracy by candidates with pending charges for heinous crimes can still contest. Public trust issue. Voters feel cheated when tainted leaders held office. Now let's understand how these all rules impacts on our fundamental rights. Article 19 Clause 1 Clause A restrictions on contesting limit political speech. Article 14 eligibility household thresholds must be reasonable. Article 21 criminal disqualification rules balance liberty with public interest, but critics say they are inconsistently applied. Key suggestions for strengthening democracy are: first, reform anti-defection law. Limit disqualification only to votes on confidence motions and money bills. Allow legislators freedom in other policy votes to restore deliberative democracy. Second, fast-track criminal trials for politicians. Special courts to ensure cases against candidates are decided within 1 year. Prevent misuse of delays to contest elections indefinitely. Third, expand fundamental protection. Recognize right to contest as a part of the Article 19 Clause 1 Clause A freedom of expression or Article 21 right to participation in democracy. This would prevent arbitrary restrictions by the statutory laws. Fourth, strengthen electoral disclosures. Mandatory real-time updates of criminal cases and assets on Election Commission website. Empower the voters with transparency. Fifth, independent electoral reforms commissions. In constitutional body to recommend changes in eligibility, disqualification, and voting rights. Reduce political influence in setting thresholds. The Supreme Court reminds us voting and contesting are rights created by law, not guaranteed by the Constitution. But reforms like limiting anti-defection law, fast-tracking criminal trials, and expanding fundamental protections could make our democracy stronger, freer, and more accountable. Let's get into the next news. When religious freedom collides with the right to life, which prevails? Today we break down the Supreme Court's hearing on female genital mutilation, the Sunita Tiwari case, and why Articles 21, 25, and Article 14 are at the heart of this debate. Let's understand what is female genital mutilation. Female genital mutilation involves the partial or total removal of external female genitalia or other injury to female genital organs for non-medical reasons. Types of female genital mutilation: clitoridectomy, removal of clitoris; excision, removal of clitoris and labia; infibulation, narrowing of vaginal opening. It affects are severe pain, infections, and complications in childbirth, long-term psychological trauma. Now let's understand its genesis and practice in India. It originates in African and Middle Eastern traditions, justified as a purity or control of sexuality. In India, practiced mainly among Dawoodi Bohra community, often on girls around age 7. No child can provide informed consent at that age, making it a violation of dignity and bodily autonomy. Let's discuss the case Sunita Tiwari vs. Union of India 2017. It was filed in the 2017, now before a 9-judge bench in the April 2026. A petitioner seeks to declare female genital mutilation unconstitutional, demand a specific anti-female genital mutilation law, and ensure prosecution under existing criminal laws like IPC, CRPC, POSCO, and the Bharatiya Nagarik Suraksha Sanhita and Bharatiya Nyaya Sanhita. The core question is, does Article 25 religious freedom protect female genital mutilation, or does it violate Article 21 right to life and dignity and Article 14 right to equality? Let's understand the Supreme Court precedents on similar issues. In Sabarimala 2018 verdict, review was ongoing currently. In that court held exclusion of women unconstitutional, emphasizing that essential religious practices must be tested against equality and dignity. Maneka Gandhi vs. Union of India 1978, in which court expanded Article 21 to include dignity and personal liberty. Shera Banu vs. Union of India 2017, Tribal Talaq struck down as unconstitutional, showing religious practices cannot override fundamental rights. Now let's understand the legal framework governing this issue. IPC and POSCO. Female genital mutilation can be prosecuted as grievous hurt, Section 326 IPC, and sexual assault on minors under POSCO. Bharatiya Nyaya Sanhita 2023, which replaced the IPC, retains provisions against bodily harm and sexual offences. Bharatiya Nagarik Suraksha Samhita 2023, which replaces CRPC, governs investigation and trial procedures. Thus, even without a special anti-female genital mutilation law, existing courts criminalizes the practice. In 2017, the Minister for Women and Child Development, Maneka Gandhi, stated that female genital mutilation is a criminal offence. If the Bohra community does not stop it voluntarily, the government will bring in a law to ban the practice. Common questions about female genital mutilation we get as the general public. Can a woman get pregnant after female genital mutilation? Yes, but complications are common: obstructed labor, infections, higher maternal mortality. Does female genital mutilation reduce sexual desire? It causes trauma and pain, often reducing sexual satisfaction. Is female genital mutilation legal in India? No, it is prosecutable under IPC, POSCO, and Bharatiya Nyaya Samhita. Is it an essential religious practice? Courts will decide, but precedents like Sabarimala and Tribal Talaq case shows that harmful practices cannot override fundamental rights. Key parallel case we can quote here is Dadaji Bikaji vs. Rukumbai 1885, which is a famous case in the Indian history in which a minor girl married without consent. When she became a major, she refused cohabitation with her husband, and the court upheld her right, stressing that consent of a minor is invalid. So we can understand the parallel to the female genital mutilation here. A 7-year-old cannot give informed consent to a permanent harmful procedure. Key suggestions for strengthening democratic rights. First one, explicit anti-female genital mutilation law that could criminalize the female genital mutilation with clear penalties. Second, child consent protection. Reinforce that minors cannot consent to irreversible procedures. Third, awareness campaigns. Educate communities about health risk. Fourth, fast track trials. Special courts for female genital mutilation cases. Fifth, constitutional morality emphasis. Ensure Article 21 and Article 14 prevail over harmful practices under Article 25. The Supreme Court must decide, does Article 25 protect harmful traditions, or must Article 21 and Article 14 safeguard dignity and equality? Just as in Sabarimala and Triple Talaq, the answer will shape the future of constitutional morality in India. Now let's get into next news. Democracy is not just about parliament and assemblies, it begins at the grassroots. When panchayats and municipalities are denied elections, the very foundation of our democracy starts to crack. Local body elections are pending in the state of Rajasthan since the 2.5 years. Congress former Chief Minister Ashok Gehlot asserted that the President and the Governor to intervene in the constitutional state machinery to conduct timely local body elections. The delay of over past 2.5 years violates the 73rd and 74th constitutional amendments, undermining the democratic and constitutional morality. Let's understand the constitutional and legal framework governing this issue. 73rd Amendment of 1992, which states that it establishes the Panchayat Raj institutions. Article 243E, which says that Panchayat's tenure fixed at 5 years. Article 243K states State Election Commission must conduct timely elections. 74th Amendment Act 1992, which establishes the urban local bodies that are municipalities. Article 243U, which states that municipal tenure fixed at 5 years. Elections must be held before expiry. If dissolved early, elections within 6 months. Let's understand the current situation in Rajasthan. The delay, the elections pending for over since 2.5 years, BJP took the power. Delay because elections pending for over 2.5 years since BJP took power. Court intervention is that Rajasthan High Court ordered elections by April 15, 2026 after petitions challenged postponement. Reason for delays: reservation subquota OBC Commission report pending. Who is held responsible for this issue? State government must facilitate delimitation, reservation and administrative readiness. State Election Commission, independent authority mandated to conduct polls. Governor or President, limited role, intervention only if constitutional machinery breaks down. Article 356. What is its impact on democracy? Backwardness of institutions. Without elected representatives, administrators run panchayats and municipalities, weakening grassroots democracy. Violation of Gandhiji's vision. Gandhiji said, India lives in villages, but village institutions are deprived of democratic voice. Constitutional morality. Ignoring mandatory timelines erode trust in rule of law. Democratic morality. Candidates lose participation rights, weakening accountability. Let's understand the criticism arising against the issue. State government accused of using reservation commission delay as an excuse to avoid elections. Election commission criticized for not asserting independence strongly. Political motives. Allegations that ruling party fears electoral setbacks at the local level. Here are the possible solutions for making process effective. First, strict judicial oversight. Court must enforce deadlines as already done. Second, time-bound reservation process. Commission should have statutory deadlines to avoid indefinite delays. Third, empowering State Election Commission. Greater autonomy and resources to resist political pressure. Fourth, civil society pressure. Media, NGOs and citizens must demand accountability. Fifth, legislative reform. Amend laws to penalize governments for failing to hold timely elections. In Rajasthan today, the absence of panchayat and municipal elections is not just a delay, it is a denial of democracy. The 73rd and 74th amendments were meant to empower the grassroots, but political excess has silenced the people's voice. To protect constitutional morality, India must ensure that no government can ever postpone democracy at the village or city level. Let's come to the next news. Telangana Hate Speech and Hate Crimes Bill 2026 is being projected as a safeguard against divisive rhetoric, but critics warn it could become a weapon against democracy itself. Let's understand the context and legislative position of the bill. It was introduced on March 30, 2026 by the Minister Punnam Prabhakar on behalf of CM Revanth Reddy. Hate speech and crimes protection is tied to public order and police, which are subjects in the state list under the constitution. Due to the opposition uproar, the bill was sent to a select committee for redrafting. Chief Minister Revanth Reddy defended the bill as necessary to protect communities from hate speech, especially online, amid strong comments from BRS Working President KTR calling it authoritarian and draconian. Let's understand the key features of the bill. Broad definition of the hate speech includes spoken, written, visual, and electronic forms. Coverage is religion, caste, gender, language, identity-based speech. Punishment is strict penalties, imprisonment and fines. Digital surveillance, heavy monitoring of social media platforms. Why opposition leaders calling it authoritarian? Vague wording could criminalize the satire, criticism, or dissent. Surveillance state, risk of digital colonialism, where online spaces are controlled by state power. Impact on journalists and critics, fear of harassment or arrest for constructive criticism. Violation of fundamental rights, directly challenges the Article 19 Clause 1 Clause A, freedom of speech and expression. Suggestions to rewrite the bill. First suggestion, clear definitions, narrowly define hate speech to exclude satire, criticism and dissent. Second, independent oversight, create an independent commission, not police control, to review cases. Third, judicial safeguards, require court approval before prosecuting journalists or critics. Fourth, digital rights protection, ensure surveillance powers are limited, transparent and accountable. Fifth, community dialogue, promote education and awareness campaigns instead of only punitive measures. Sixth, sunset clause, add a clause that requires periodic review of the law to prevent misuse. In the name of preventing hate, the bill risks silencing voice of truth and dissent, raising the question. Is Telangana protecting its peoples, or it is paving the way for digital colonialism? Leaving you on that note, thank you for watching.